is Elliot Stapleton, and today I'm going to cover medical directives related to estate planning. So for most clients who create an estate plan, we also go over what happens if you are disabled or terminally ill. So we go over a discussion on those two topics and go through key questions and items that we lay out within the plan itself. What I'll cover today is how to address those items if you've been named in the person's estate plan. So first, let's talk about the devices used. There is first a healthcare power of attorney. So a healthcare power of attorney allows you to appoint someone to make health decisions if you are unable to do so. The benefit being that with this healthcare power of attorney, you avoid a guardianship, which a guardianship is actually in probate court. So it is a lot easier to have a healthcare power of attorney in place rather than having to go through a whole court proceeding to be appointed as someone's guardian. So most clients have the healthcare power of attorney created and have a line of succession, so first, second, third, etc., on who would serve if they were unable to make their own medical decisions. Also, there is a living will. What this living will does is it provides insight on a person's preferences related to life-sustaining treatment and end-of-life care. So in essence, if a person is too far gone to recover, what does that person want to happen? And that can be laid out in the living will, that if a person is terminally ill, permanently unconscious, and these two physicians say that the individual is not coming back, the living will could say, in that instance, I, being the person signing the document, do not want to be kept on life-sustaining treatment. Now, in some cases, clients will have the living will as the prevailing document, meaning if those standards I just went through are satisfied, meaning terminally ill, permanently unconscious, etc., the living will is the roadmap that the physicians have to follow. So if those two physicians examining the person agree on the medical standards, then life-sustaining treatment would be removed. In other cases, clients decide, well, that's fine, I want the doctors to examine me, but I want the agent to have the final say. So in essence, the healthcare power of attorney can prevail over the living will. So the healthcare power of attorney, the agent, could veto the terms of the living will if they disagreed with the circumstances at that time. And this is always a hard decision for clients to make. Do I have the living will prevail over the healthcare power of attorney, or the healthcare power of attorney prevail over the living will? There's no right or wrong answer, but the key is to review the document with the attorney who you're working with, if you are appointed as agent, to confirm which one does prevail. And still in other cases, some clients don't have a living will, meaning they want the agent to make all of the decisions. And perhaps they never want to be removed from life-sustaining treatment if they are able to be kept alive by that life-sustaining treatment. Another key question is, what about organ donation? So some clients opt in, some clients opt out. This could be found on the person's driver's license, meaning they may say it on the license and say, I'm an organ donor, which would of course be opting in. Some clients don't put it on their driver's license, but still opt in their estate planning documents. And then of course others may opt out on their license and in their estate planning documents. So the key is, you don't want to make a snap decision if their license says, it has the absence of organ donation on it. That doesn't necessarily mean they don't want to be an organ donor. In the healthcare power of attorney, it will say unequivocally, I want to be an organ donor or not. And it may even provide specifics, just for transplant, research, etc. So the key with all of these decisions, if it comes up, seek legal counsel where the person is located, and make sure that when you're going through the process, you review all of the documents with the attorney so you understand what your duties are and how to carry them out. Thank you.